Thank you, Anthony, for your comments. We truly appreciate you sharing your story with us. And I think there's no doubt, if I can hold it together, that was the most powerful moment of the day that we'll have. And now, at this point, we'd like to spend a little time talking amongst ourselves here up at the panel, and also with Meg McCracken, who we have on the phone. Meg, can you hear us effectively?
Yes, I can. Thank you.
Okay, great. And actually, Meg, we'll start out with you, because what I'd like to do is talk about some of the other issues that the report touches on. Certainly, we can't be exhaustive in the time that we have, because we've covered a lot of material in the report. But I'd like to bring out some of the other topics and see if we can get your thoughts on all of them. And I'll remind all of the panelists that if you want to speak, you need to actually push the button so that your light turns green so that we can all hear you. So, Meg, the topic I'd like to start with during our panel discussion is a topic that many people think of when they think of the death penalty, and it's one that's been in the news this month, certainly, and that's lethal injection. Meg, can you tell us a little about what happened last week during the Lockett execution in Oklahoma, which, as I think everybody in this room knows, went terribly awry?
Sure. I think that there were several factors at play in Mr. Lockett's execution, in the lead up to his execution. Can people hear me?
Yes.
Okay. There was a rush to execute both Clayton Lockett and Charles Warner, who was scheduled to be executed 2 hours after Mr. Lockett. There was a rush to execute with the state's new protocol, using a new drug formula that used 3 drugs at doses that had never been used before in an execution. There was an intense legal battle and political pressure on the Oklahoma Supreme Court to say that it's okay to move forward with an execution where the procedures are shrouded in secrecy and the necessary information about the drugs has not been revealed. There was an execution team unprepared and incompetent to perform the tasks assigned to them. And then, as I said before, there was secrecy regarding the pertinent information about the drugs to be used. What are these drugs specifically, and who made them? And so Mr. Lockett's horrific execution was the predictable and foreseeable consequence of the state's rush to execute without transparency and without an execution team that was qualified and competent to perform the procedures appropriately. The information continues to slowly come out of Oklahoma, and so we now know that Mr. Lockett had one IV set in his femoral, well, not set, but intended to be set in his femoral vein, which is in the groin. It appears that that IV was not actually in the vein, meaning that the drugs were not delivered into his circulatory system, but likely into his flesh. I'm saying words like likely and it seems like because, of course, we don't know. The information is not out, and so unless and until there is a thorough, transparent, and truly independent investigation of what happened at Mr. Lockett's execution, we cannot say with any certainty at all what really happened. I can say what appeared to happen, and that is that the drugs did not go into Mr. Lockett's circulation, but rather into his flesh, and therefore were absorbed very slowly. He remained conscious long after it would have been expected that he would be unconscious and unaware. And then the state closed the curtain. And so the witnesses were not able to see what was happening, and 27 minutes later, they were informed that Mr. Lockett had died.
All right, and Meg, there's some related issues, one of which you touched on during your answer just now, which was the issue of secrecy that surrounds the access to many of these drugs. And there's also the issue of where we actually get the drugs from that are used during executions. Can you talk a bit now about the current controversy surrounding both of those issues and how they play into lethal injection procedures that the states are carrying out right now?
Sure. So unlike maybe 10 years ago, even 5 years ago, right now what we see happening across the country is that states are carrying out executions in ways that differ from one another. They're changing their protocols using new drug combinations at different doses, whereas we used to see that every state used a 3-drug protocol. There were differences between them, but they all used the same 3 drugs, just at varying doses. Today, we have states with 1-drug protocols, 2-drug protocols, and 3-drug protocols. And then within those, they're using different drugs at different doses. So there's just a lot. It's a very dynamic and shifting landscape. At the same time that states are using novel and experimental drug formulas, they are also increasing the secrecy surrounding their procedures, particularly secrecy surrounding their drug sources and what the drugs really are. In the report, Debbie Deno identified intensified efforts on the parts of the states to obscure information regarding the development and implementation of their protocols, and that's exactly right. Several states are using compounded drugs. These are drugs that are made to order and mixed from raw ingredients by a compounding pharmacy. These drugs are not FDA approved, and although they certainly meet a crucial need in medical care, using them in execution unnecessarily brings risks of pain and suffering to the process because there is no guarantee of what's in the syringe. Other states are using new combinations of drugs, and I am so sorry, everyone. I'm going to put this on mute because here's my child trying to talk to me.
Yeah, I think so. Okay. Meg, if you can hear us and you're able to come back, please join us. We'll just turn the panel right now to talk about another topic for the moment, which, Mark Earley, you had commented upon this during your opening remarks, but isn't the crux of many of the problems in the context of handling capital cases the inequity between the available resources between the prosecution and the defense?
Yes, it is. There's a tremendous, historically, a tremendous inequity in resources. You know, the prosecutors, they don't always have all the resources they would like, but the fact is they have far more resources historically than the defendant lawyers for capital murder cases. It's getting better now as states make needed reforms and fund death penalty centers in the states, train lawyers, provide money for investigators, provide money for the defense team to do the kind of hiring of experts that they need to do. But it's still amazing in court-appointed cases in general and in death penalty cases how much you have to fight to get the court oftentimes to approve resources for you to defend your client. So, and certainly when a life is at stake, there ought to be a level playing field between the prosecution and the defense. So that's why one of the recommendations is, not only to train and have very well equipped defense teams to represent those charged with capital murder, but to have them well funded and well resourced as well.
Mm-hmm. And Mark, you also spoke in your comments about what's the Strickland Standards, so the test for defendants to be able to show that they had ineffective assistance of counsel and the high burden that imposes on defendants in their struggle in order to make that showing. What kinds of problems does that practically mean for defendants under the current standard that we have?
Well, what it practically means is, you think you might have given yourself a shot at the merits if you show that you had a lawyer that didn't rise to minimum competency standards. And in some of these cases, that's putting it very nicely. Some of them, the representation was just truly abysmal. But then to have to show that even if you had competent counsel, there is a reasonable likelihood that you would have been found not guilty is very difficult to do without getting your case before a judge to talk about those very merits. I mean, you have to show it on paper initially, and that's very hard to do because you're pretty much stuck with what was there at the trial. It makes it difficult to get to new evidence. In Virginia, when I was Attorney General, we had a 21-day rule, and if you didn't get in new evidence after 21 days of the judgment, you had to fight like crazy. It was just really, really difficult. So to put that sort of burden on someone, we just think the burden ought to shift to the state. If the defendant who's been convicted of capital murder and now faces losing his life has shown that he had incompetent counsel, then at that point the burden ought to be off him or her, and the state should have to show that even with that incompetent counsel, they would have gotten the same result.
And how do these attorney competence issues play out in the context of defense counsel's decision to offer or not to offer mitigating evidence? So evidence of characteristics that would counsel a jury against recommending or issuing a sentence of death.
Well, I think the point you bring up is, obviously most people in this room, I'm sure, fairly understand the legal system pretty well, but, a lot of lay people, when they look at a death penalty case, they think, okay, he's been, found guilty of the crime. Now it's pretty much over, and the jury's just going to decide whether he gets the death penalty. Well, that next stage, that bifurcated part of the trial that is all about now deciding, all right, he or she is guilty, should they get the death penalty, is as technical and as important, and the life hangs in the balance just much in that part of the trial as it did in the first part, if not more so. And so, the ability of an attorney to be skilled in presenting evidence about that individual's background, about their mental capacity, about, all the things that could mitigate in the mind of the jurors the necessity of the death penalty is not just something you sort of come in cavalierly and talk about. It is a very nuanced, technical area of the law that requires a lot of training and experience as well. So it just highlights the need and highlights the fact that these cases are highly technical, highly involved, and, they're not for laymen. I mentioned I got appointed on a case when I was 2 years out of law school. I mean, thank God that case never went to trial. We were able to just provide the detectives with evidence they had the wrong guy, and they bought it. Well, that doesn't happen very often. But can you imagine me 2 years out of law school jumping into that sort of thing? I mean, I should have never been appointed. I should have never taken the case. We need people who are highly trained. This is what they do. They're the heart specialists of their careers.
And Anthony, I don't want to put you on the spot here, but I'll put you on the spot, which is certainly, I know you've seen a lot of cases with these issues. You've talked to a lot of people who've had issues like this, competency issues, ineffective assistance of counsel issues in their cases. So to the extent that you have comments about what we can do better, we'd certainly like to hear your thoughts as well.
Well, what we can do better, I think that, first of all, we're not going to get where we need to go until we change our attitudes toward this thing. Okay, I think that's the first thing. We need to understand that because what this man done may have emotionally traumatized us, that's not where we get our verdict from. It should be a rational thinking process. Okay, we don't have that. We have an emotional thinking process. Prosecutors get up, sell their story to the jury, tap into their emotions, and get a conviction. Nobody's heard about the facts anymore. I think a big problem that we have is we don't have an educated juror sitting up there. I think when it comes to capital cases, what we should be doing once we sit a jury is we should be giving them at least 3 to 5 hours of training on what their job requirement is. We get 12 people off the street, and we go in there, and they don't even know about the system. Most time when they come off the street, like you're talking about a layman. And we go in there, and we ask them to make the most important decision in that courtroom. Yet they were the most uninformed. They don't know anything about suppression of evidence. See, they don't know how, when a judge sustains or overrules, how much of an impact it has on the outcome. They're caught up in their emotions because a prosecutor has sold them this story. even cried to him. And it takes away from the facts of the case. So we have to get back to this whole attitude of seeking justice, regardless of what side you're on. When a man walks in that courtroom, he should be innocent unless proven guilty, not until. That's a setup. Because you're saying we're going to get there eventually. He should be innocent unless proven guilty. That should be changed in our law. So I just think the reforms start at the initial stage of the case. The arrest, that should be guidelines. That should be this here videotaping and audio. I'm telling you, this is needed. Because a lot of times what happens is when you get a recorded conversation, usually it's a confession. Why? Because hours before he confessed, he was tortured. Okay, he was told that he's a murderer and that he would never go home. Okay, and then they got him to where he said, okay, well then if you just tell us, we'll let you go or we'll help you. And then you get the recorded part. Oh yeah, I did it, da da da.
And just for a point of reference, you're talking about the report recommendation that
yes, I'm talking about the report
all interrogations be recorded,
yes,
preferably audio and video recording, and from start to finish,
and
not
from
just
start
the admission part.
Yes, exactly. And look, with me, I just started my foundation, and it's geared to what Mr. Earley was talking about, providing resources to independent defense counsels to help support them. Because when you look at it, you have a state that it has so many entities to help support them. FBI, Texas Rangers in Texas, and on and on. And then you look on the other side of the table, and you got this overwhelmed, overworked, underpaid, indigent defender representing this young man with no resources. You're not going to get to justice. We're not going to get a fair trial in that setting because, number one, this guy can't even defend himself. He don't have the resources, and his attorney is so overworked and being pressured by a judge to move his cases along that our system has now sort of been set up to plea bargain. That's where we at now. We at let's make them plea bargain. Right? I just think that we just gotten away from wanting the system to be fair for all, and we're about trying to convict someone now, and that's a big problem.
All right. I understand that Meg is back on with us. Can you hear me okay, Meg?
Yes, I can.
Okay, great.
All right. I apologize for the disruption.
That's all right. I just wanted to follow up on some of the points that you were making about the access to information about the source of drugs and the makeup of the drugs. How do we fix those issues? How do we help resolve them? I mean, what's the answer to trying to get transparency on those topics? And from a legal perspective, I know you've done a lot of work in the Eighth Amendment area. Has there been much success in that regard? What kinds of efforts are being made?
Sure. So, just of course, we're referring to Recommendation 37 from the report. Jurisdictions should act with transparency in the development and administration of lethal injection protocols. What we are seeing at this moment when states are changing their protocols using new drugs and new combinations of drugs is a simultaneous intensification of the secrecy surrounding the procedures. And so, in addition to the identity of the execution team members, which is appropriate information to make confidential, they are also making confidential the source of the drug, which could, in the end, hide what the drugs really are. So when some states are using manufactured FDA-approved drugs, other states are using compounded drugs, which are not FDA-approved. And so what is at stake here is knowledge of what the procedure really entails and whether or not the drugs will work as intended. It's crucial to know what is in the syringe at the time of the execution, and you simply cannot know what that drug is, what the product is, and whether it will work as intended unless it has FDA approval. In terms of the court's view of these issues, we see a mixed bag. So in the state of Georgia, where the secrecy statute goes a step farther than others and makes the information about the sourcing of the drugs a state secret, meaning that the court cannot see the information, the trial court took exception to that statute, declared it unconstitutional under the state constitution, and that decision is on appeal. It's been argued in front of the Georgia Supreme Court. We're waiting decision on that case. Similarly, in Oklahoma, the state trial court found the secrecy statute, which was challenged prior to Mr. Lockett's execution, to violate the state constitution. The Oklahoma Supreme Court eventually postponed Mr. Lockett and Mr. Warner's executions in order to take a close look at that decision on appeal. But then the intense political pressure from the governor and from the assembly in Oklahoma came down hard on the Oklahoma Supreme Court. There was talk of impeaching the justices who had voted for stays of execution in order to review the decision that the secrecy statute violated the state constitution. And shortly after the political pressure ratcheted up, the Oklahoma Supreme Court reversed course, decided the case in 48 hours, and allowed the executions to move forward. And as Governor White spoke so eloquently about before, we see what the consequences of that decision, what they were.
And Governor White, that's a natural segue to you, and just so you know, let me turn that on for you.
Thanks.
I think we all have probably seen that as a result of the awry Lockett execution last week, that the Oklahoma Department of Corrections director called for an indefinite stay of executions until the state changed its execution procedures and staff were retrained. Initially, the governor of Oklahoma stated that she would have a complete review of the state's execution procedures conducted. But I saw an article yesterday where she stated that justice was served and the people of Oklahoma do not have blood on their hands. In how much, in your assessment, do politics play into this? And is there a place for politics here in capital punishment?
Yeah, I'm afraid to say politics plays a major role in it. I regretted one of the spots that I put on television sometime after I'd left the governor's office in an effort to regain it. Was in poor taste, to say the least. And the pressure on these people is enormous. But yet that's where leadership, I guess the best way to put it, that's really what leadership's all about. It's pretty easy to let the crowd determine the direction that you go or one goes, when in fact the importance is to stand up and say, and we've seen governors who've done it. Governor Richardson in New Mexico presided over the repeal of the death penalty in their state. And at some stage, I think, when the facts are known, the people in this country will say, there's no way that you can have the assurances that you need to have to be certain that this person should be executed, as was just pointed out by Anthony, that right now we're little better than a trip to Las Vegas on getting this thing right, and that's not very good. Everything you see in this report, if implemented, still doesn't get you to where you have the certainty that we're right. And as a result of that, for those people who claim they don't want government involved, they want too much government involved, we've got to rush to justice. What's more important than the life of an innocent person? That's the ultimate importance. That's of the ultimate importance in a free society. And to jeopardize or to place in jeopardy that person's life because we didn't get it right, getting it right is much tougher than I ever thought it would be. Cool reflection, and that's what this has been, evidence of the result of lots of cool reflection, points out the past discrepancies. What I thought was a certainty was not certain after all. What we all believed in before that eyewitnesses were the best witness you could possibly have. Oftentimes, it's just the most flawed witness you could have. The tests that we thought were certain about whether this was a arson or not, just absolute flip of the coin. Fact is, what even flip of the coin? You were always wrong if you claimed it was arson based on what they were presenting as the evidence of arson. That was zero. That had zero impact on whether, or on the question of whether it was arson or not. We've been so horribly wrong in the past when we thought we were certain. Even by passing everything we suggest here, we will then think we're certain? No. And that's what Anthony's talking about. And that's what I think America needs to hear, is this is such a fragile process that just getting it right for punishment is a tough enough deal. And then going to the death penalty, my thoughts on this have changed dramatically over the years, and this has focused most of my change right here.
And Governor, we heard during Ginny Sloan's introductory comments that there's a sizable portion of the audience that represents other countries as well. How do we square the continuing use of the death penalty in a majority of states in this country when virtually every developed or developing country has, put it by the wayside?
Well, those people who decry Sharia law and they decry all of this uncivilized approach to justice looks to where they do many of the executions, they're right there. And just by guilt by association, is that what we want? How do we compare ourselves as a country? Which side do you want to be on? We're far better off. And let me wait just a minute. What he said, nobody heard. Nobody heard the real cruel punishment that's there in solitary confinement. How many people decided they'd rather die than go forward with that? That is cruel. That is tough. Solitary confinement in the state of Texas or anywhere else is a very cruel punishment. And we have people that sit there for years in solitary confinement in our state because that's the way it's gone. That's not a good system either. We're in very weak standing, I think, on the business of Eighth Amendment protections when you talk about ADSAG.
Yes, sir.
Man, this is as tough as it gets. You don't get a lunch. You get served lunch, but you don't get a lunch, do you?
You might have rat feces in it. You might have a roach in it.
Explain to them what the food is. Do they still give you that?
No, they give us dehydrated food. They put it in a hot box and let it sit out there for hours while they do whatever they want to do. And then when they decide to serve you, they serve it to you while your food is dried out. It's a little of nothing. All the produce comes from, they grow it themselves. You don't get any kind of real meat. You just get some synthetic whatever. But you're never going to get a good meal down there. All you're going to get is hell. That's it.
Do they give you the food that comes through the blender or just all packaging?
Some of them, yeah, they call it a food loaf. Yeah, and they give it to the guys in solitary. They give them a food loaf. What they do is they take everything that they made throughout their day, put it all together, bread, milk, everything, and then they'll bake it. It's a food loaf, and then they'll go and give it to the inmate, and that's his meal. And it's no telling what's in there.
Well, that's maybe the next inquiry that this organization ought to have is exactly where you go. If you don't have a death penalty, what's the next step? What we're doing today, as Anthony points out, is a very rough procedure. I mean, it makes waterboarding look like you're just getting your sinuses cleaned out.
Yes, sir. You're right. You're absolutely right.
Can I just follow up on a couple of things, not the menu items, because it sounds like my cooking. But anyway, two things. One on the fact that the U.S. has the death penalty and has felt somewhat, I think self-righteous about it, and other countries have let it go. One thing I'll say about that, and it's not so much in defense of the U.S. as much as it is, I think, maybe understanding. I think most Americans feel like America has the best criminal justice system in the world. I mean, if you're going to be we have so many rights here that are not prevalent in other countries, and I don't take anything away from the representatives of other countries here today, but Americans feel like they have a great system of justice, even though it's flawed. I think because of that, they've had an undue confidence in the fact that the death penalty, as part of that system, was also solid, that the way it's administered. I think what's happened over the last 20 years is I think more and more people, both those in the criminal justice system and those lay people on the outside looking in, realize this administration of the death penalty is a whole different can of worms. It is very complicated. There are many, it's not what it always seems. And so I think they've realized, well, yeah, we may have one of the best criminal justice systems in the world, but on this particular area, we either need a lot of reforms and need them quick, or we need to set this aside like other countries have done. But I think in part of it, I know for me, you just, you feel so confident about the U.S. criminal justice system that it makes you feel confident about this part of it too. But then when you get involved in it, you see, oh my goodness, there's so many inequities. There's so many places where due process falls apart. Politics does come into it in ways that are embarrassing at times. So I do think that's part of the mental makeup that have had us hold on to it. The other thing I wanted to mention that I forgot a minute ago about well-trained counsel for defense attorneys. If you look at the states, and Virginia is an example of this, that have recently increased the emphasis on making sure that the playing field was level and that defense lawyers were well trained, that if you got a death penalty lawyer that was appointed, this is all they do. They're well trained, they're well equipped, they are specialists. The number of death penalty cases have dropped dramatically. In Virginia, they've just dropped really dramatically. And part of that is because now those charged with the death penalty do have good representation. And so different results tend to occur. It's not always exoneration or acquittal, but it's often not the death penalty.
And Mark and Anthony, I want to pick up on a topic that you both have touched on in your comments and in question answers, and that's this issue of race and ethnic disparity, because I think we'd be remiss if we don't touch upon that in our comments on the panel here today. And so, Mark, I'll ask you to start in terms of how racial and ethnic disparity are factors into charging in prosecutors' offices, or does it? And what effect does it have on sentences that we're seeing that are death sentences? Related to that, I think it's also important to talk about proportionality review, which is the report spent some time talking about proportionality review, which is not just race and ethnic disparity, but also comparing a particular crime in one case with a particular crime in another case, same factual scenario in two different jurisdictions or the same jurisdiction, and are the same charges being meted out? Are they resulting in the same sentence? So, Mark, based on your experience as former Attorney General, can you comment upon those issues?
Well, actually, I'm going to toss the proportionality issue back to you because you know so much more about this than I do. But I'll comment about the race issue. And simply, I just will put it this way. Any inequality, discrimination that you have in society at large comes into the door of the justice system. It just does. It's the justice system is not some isolated place from the things that bedevil us in society as a whole. So for anyone who doesn't think that historically, in a hugely significant way, and even now today exists, decisions that are made based on people being in poor economic conditions, their race, their ethnicity. I mean, if it's in society, it seeps into the criminal justice system, and it doesn't just seep. I mean, it's there because the criminal justice system reflects the larger, problems that we as a society have. So, I mean, we had a jurisdiction in Virginia, I mean, that was just embarrassing for a long time. It was the Danville area of Virginia, and the prosecutions there of death penalty were so racially egregious that it was like you couldn't suggest that it didn't exist. It was like an 18-wheeler coming down the highway at you when you looked at the statistics. So it's there. There's a lot more focus on it now than there was 20, 30, 40 years ago, but it's still there.
All right. We have barely touched on the topics that the report covers, and I urge you all to take a look at it, certainly. But we want to open it up now for any comments or questions that the audience may have for our group of panelists.
I want to thank the Constitution Project for this wonderful report. I'm Robert Whiteman. I am on the staff of the European Union delegation to the United States, and so I have several colleagues from other member states of the European Union here, from other embassies as well. But I have two questions. As you can tell from my accent, I'm not a European. I am a resident of 30 years of the state of Virginia. But my first question is to Governor White. There's a man who's scheduled in Texas on the 13th of this month, Mr. Campbell, who apparently has some mental inabilities that would fall under the category outlined by the Atkins case by the Supreme Court. The system in Texas seems to prevent a rational consideration of additional evidence at the very last stage. The role of the governor seems very limited, and the Texas Board of Parole and Pardons and Parole seem almost inured to any new information whatsoever or anyone else's opinion. I would just like to raise that as an example for you of the difficulty I have when we get letters from your successors. We have stacks of them, and the results have not been very good. So that's really a comment, not a question. But
well,
I think the fact that the Supreme Court of the state of Oklahoma could change its mind due to political pressure in less than 48 hours should terrify every American in this room. This isn't a question of just one man's guilt or innocence or a process. This is a fundamental operation of our Constitution. I mean, this is really, to me, a very terrifying lesson, and hopefully more Americans will find out about this. And I've forgotten my second question for Mr. Earley, so he's off the.
I thought you, being from Virginia, you'd ask him that question.
We like to pick on Texas.
I noticed.
So big.
I think our current governor has found out, at least to some degree, that as much as we may love Texas, very few other people love it as much. But let me say the reason we have it set up the way it is because we had a former governor named Paul Ferguson who was selling pardons, which was another way to get out if you had enough money. And as a result, they created the Board of Pardons and Paroles, which said the governor can't do anything without the recommendation of the Board of Pardons and Paroles. Of course, the governor appoints the Board of Pardons and Paroles. And you can see the history of that is that, and I must confess, they will generally do what the governor asks them to do. And so that's kind of one of those deals where you can hide the ball. This question you raised over mental retardation or mental competency, I don't know the latest code word for that, but
I think the report uses intellectual disability, which is the emerging trend.
Which is a much broader thing than mental retardation, in my view. Say it again, what did you call it?
Intellectual disability.
Intellectual disability. Woo!
Unfortunately, I'll tell you, the Supreme Court still uses the term mental retardation. So in the discourse, there's been some change, but not in the case law.
Well, anyway, that's also constrained by federal procedures, which we did not get hearings in the federal court because a prior use of the federal writ had been exhausted on a fellow who had failed the Texas mental retardation test administered by the state, as I described earlier. I don't make any. I'm not here to make apologies for it. It's certainly an error. It's something that needs to be changed. I doubt that we've changed. I don't think we've changed the law since the case, which speaks on the Supreme Court case. What is Adam's case on the
Atkins case?
Yeah, and so I'm not sure we've done anything there except try to avoid it. That's a mistake. I'm sorry. I hope that's.
Although the report does make recommendations in that regard.
It does.
So if we're looking to change that, those recommendations are in there. I think we have time for one more formal question, and then some of us may still be here for a little while if people have additional questions. Go ahead.
My question's for General Earley. You made the comment that the U.S. had, in your view, the best criminal justice system in the world. And I'm wondering on what basis you make that, considering the fact that we imprison more people per capita than any other place in the world, despite our touted rights.
Yeah, that's a really good point. I spent 10 years after I got out of politics as the president of Prison Fellowship, which is a international organization that works with prisoners and their families. And we were very involved in public policy issues of trying to reduce the mass incarceration that's occurred in the country. So you make a good point. I mean, I think we, perhaps like on the death penalty issues, we have maybe a bit of a naive sense that it's the best in the country. I mean, I'd still rather be charged with a crime here than anywhere else. And I've traveled in a lot of places, and I've been to prisons all over the world. But the fact of the matter is we do incarcerate too many people for nonviolent crimes, and that should change pretty dramatically and rapidly. So, yeah. So, great point. Touche. I agree with you.
All right. With that, I thank you all for coming. I thank our panelists for being here, sharing their comments and thoughts with us, and, of course, the Constitution Project for just their fantastic work.